Welcome to another episode of Legally 40ish. I am Natasha Axelrod.
And I'm Allegra Rainier.
We are two attorneys who are almost 40, so hence the 40ish, and we talk for 40ish minutes about politics, law, reality TV, celebrity legal troubles. Think CNN plus E-News plus a little bit of C-SPAN. And we're here. So today we have two topics, one of which is a little lighter than the other, Real Housewife. And then we're going to talk about abortion and what's going on at the Supreme Court. So Allegra, what's going on with Shannon Beador?
It's Beador.
Oh, okay. So you can tell I've never actually watched an episode of Orange County because.
Yep. Well, it feels kind of silly to be talking about such a stupid topic along with Roe v. Wade, but here we are. So Shannon Beador is in the news because, well, let me give you a little backstory. Shannon is an OC housewife. Did you know that?
I did know that.
Okay.
Because you told me.
Okay. So Shannon is an OC housewife. She's actually a pretty good housewife. Like, she's not someone you love or really hate, but she's someone who's like kind of batshit crazy, but in like a funny way. And when she came on the show, she came on, I think, in season 9. So I don't know, a long time ago, 2014 or so. And she was married and her husband's super wealthy and they lived in this beautiful mansion, and she had 3 kids, twins and another daughter. So 3 girls, and seemingly had this, kind of beautiful life. And she's one of the housewives who actually puts everything out there, like to the point where it's a little cringy, but you want to watch.
A little cringy. Okay.
I mean, fully cringy, but you still want to watch. She's kind of like that kooky, but if you give her she's like 1 tequila away from a total breakdown. So it makes for good television. But so we saw her, what's seemingly in a happy marriage and with their 3 kids, and along the way, because she does share everything, her marriage kind of took a hit, and her husband ended up cheating on her, and then they tried to repair their marriage. They even did vow renewal, which is a kiss of death on the housewives. Pretty much any couple who does a vow renewal ends up in divorce. So then she had and some of what she went through is relatable. So that's kind of what also makes her a good housewife. But anyway, so she ended up divorcing her husband, David, and that played out on the show. And then she had a really nasty divorce, really contentious divorce, settlement negotiations. So that's what's in the news. She settled her divorce with David back in, I think it was 2019. So 2 years ago. And we saw it on the show. He ended up agreeing to pay her something like $1.4 million. Plus she's getting $10,000 a month in child support for 10 years. And that's essentially the all we really need to know about the divorce settlement. Well, she's now suing her divorce attorney for malpractice. And it kind of looks she's really just has buyer's remorse. So
here's the legal issue. Malpractice is a real thing that attorneys can be held liable for. It means they did something wrong, and typically you get sued for money damages. But the thing is it actually has to rise to that level, and just having buyer's remorse, being I don't like what my attorney did, even though I agreed to it at the time, typically doesn't rise to the level of malpractice. What is the significance here? Is there malpractice? What's the allegation?
So that's what's kind of interesting. So I pulled the complaint, and a complaint is actually the legal document that you file with the court, which states all of your allegations against the defendant. So in this case, she has to lay out basically her cause of action, why she feels that her attorney committed malpractice, and she has to allege specific things. So she's alleging, and honestly, it's a really terribly written complaint. It's a form complaint. And there's nothing wrong with a form complaint, but at least have something intelligent to say. So I'll give you the main points. There's pretty much 9 bullet points of the things that she claims are malpractice, some of which clearly are not, but I'll just touch on the ones that perhaps, I guess, could be. So she alleges that the defendants, and when they discuss defendants, it's her attorney and the firm that he works for. So defendants failed to include the cost of plaintiff's children ongoing education. So they have 3 children, and she's saying that they didn't include the cost of him paying the children's college education. Another one, the defendants failed to negotiate and include a filming release from plaintiff's former spouse for plaintiff's children so that her children could continue to appear in their roles on Real Housewives of Orange County. This other one is that the defendants retained a second unnecessary forensic accountant without informing her and incurred charges of about $85,000. The other ones that are kind of minor, that they repeatedly assured her that she was going to continue her lifestyle and that they were uncommunicative with her and that they failed to adequately argue and present evidence that her income was less than David's income. So
what does this mean? Where are we in the stage of this lawsuit?
So she filed her lawsuit. It looks like she had an arbitration agreement with her former attorney, meaning the case won't actually be heard in court. So we won't really get to know what's happening. It's going to be forced into an arbitration, which, if you don't know what arbitration is, it's kind of like a mini trial, but within a neutral. I don't really know how to describe it. It's not in a courtroom.
It's a private matter. It's like, and so you can agree to anything in there, right? You're not bound by rules you would be bound if you were in civil court.
Yeah, I mean, there's still rules for arbitration, but it's a lot different. It's a lot looser, and the process is much quicker than if you were going to be in a regular court. But so these are the things she's alleging that rose to the level of malpractice, and she's essentially saying that because of you did these things, I didn't get as much money as I should have or could have if you hadn't done them. But not liking what your attorney did or the strategy that they employed isn't grounds for malpractice. It's also not, and then we're dealing with a settlement here. So when you deal with a settlement, if anyone's ever had to come to an agreement with someone and then sign a settlement document, they've reviewed those terms. They've had an opportunity to consult other people to find out if this is a good agreement for them, and then they sign it. And so it's really hard to now go back and say, my attorney committed malpractice because you agreed to this and you signed that settlement agreement.
Yeah, typically, I mean, and who knows, maybe they didn't do that, and but typically that's what's supposed to happen.
Sure. And she's not alleging that didn't happen. So I would think if you know what I mean, if the agreement didn't have those provisions, then that probably could rise to the level of malpractice.
I have to say, given what she's complaining about, I'm trying to manufacture some type of sympathy and I can't get there. Like, I mean, come on. There are very, very, very sad divorce situations. Obviously, it's a terrible thing that no one I think wants to necessarily go through. So on that level, it's sad. But, we're talking about a lot of money here in a life. This is just so, I guess this is why the housewives are popular, right? Is it's so out there in terms of, this is not what everyday people are dealing with, of like, oh, you only pay me $10,000 a month and my children need to keep appearing on this show. I mean, that's just like, I was trying not to roll my eyes. I actually can't, because my eyes kind of hurt from staring at the computer all day. So I actually don't know if I can roll my eyes. But anyway, yeah, it's hard to, I mean, that's just, I get it though. That's what this whole thing is about, is just the kind of ridiculousness of the lifestyles of the rich and famous a little bit.
Yeah. And I think
housewives.
I think also, I mean, well, so I consulted with an attorney, a friend of mine who practices in family law, because I'm like, are any of these things actually malpractice? And she specifically told me, especially with respect to the paying for the children's college education, is that parents have no obligation to pay for children's tuition for college.
So I was wondering that, like, there's no constitutional right to college. There's no general right to college. Like that is it's not required. Like,
yeah. So that one, no, of course, if the parties agree to it, sure, but they didn't have to. And then also, I think something just to consider for anyone who's watched the show and saw what kind of lifestyle Shannon had, it was pretty extravagant. And she was a housewife when she came on the show. I mean, I don't think she had a career of her own other than, being a mother to 3 children, which is a ton of work. But at some point, and it's something they don't ever discuss on the show because it's kind of like breaking the fourth wall, is these women become celebrities themselves. They become high earners. They make a fat paycheck for being on the show, plus all of their endorsements and, probably Instagram ads and all of those sorts of things. So once she starts making a significant amount of money, she's not going to get as much money from her ex-spouse in a divorce. So I think if you know Shannon, she just seems, and of course, I don't know her. I'm saying this as a viewer of the show.
I don't know her at all, but
I mean, that sounds so stupid. But if you watch the show, it kind of is in alignment with her personality. She's just like frantic and kind of a mess. And instead of just putting this to bed and moving forward, it seems like she's someone who wants to continuously like have this spiral, this people like that kind of cycle of chaos. And she's definitely seems like one of those people. So I don't think we'll ever find out exactly what happens. I don't think that this is a valid claim for malpractice, but it's interesting in that it's just kind of entertaining. But I don't think she's gonna be able to win this case necessarily. We'll see maybe we'll find out, but arbitration and whatever agreement they come to probably will be private and confidential. And last thing on this, because we need to move on, we have a much more important topic, but I looked up the attorneys representing her in this case, and they're like they're not legal malpractice attorneys. They're not professional. Like they practice in civil litigation and commercial litigation. So they must have represented her in some other capacity, because it's definitely not a professional malpractice firm. So I just thought that was kind of interesting. I think she must have just found someone who was willing to file a form complaint and see what they can do. Okay. Let's move on. We had Shannon in the news this week. Also, I think the same day actually that I read about Shannon's legal troubles, something happened in the Supreme Court, which is pretty significant in Roe v. Wade. So tell us what's going on.
Well, something always happens significant at the Supreme Court.
Oh, geez. Well, this is significant because people might actually pay attention.
That is a fair statement.
Okay.
So the Supreme Court decided to take a case that directly challenges Roe versus Wade.
And what does that actually mean, though?
So Roe versus Wade was decided in 1973. And as I'm sure, even if you pay no attention to politics or Supreme Court or constitutional rights, you've heard about a right to an abortion. Or abortion is like that is just the polarizing issue of our time.
When people talk about abortions, whether they should be legal or illegal, and when we talk about Roe versus Wade, I think and you said it was decided in 1973, but what did that mean?
Well, what Roe versus Wade did was recognize that a woman has a constitutional right to decide whether she wants to terminate her pregnancy pre-viability.
Okay.
So that's significant because one of the kind of myths about abortion is that you can just get an abortion on demand and it's just like anytime you want. And that's never been the rule. And it's not an absolute right. It's never been an absolute right, meaning states can regulate a little bit. And Roe versus Wade discussed this. They balanced the compromise was a right to a pre-viability abortion because they balanced a woman's right to choose to make decisions with the state's interest in regulating for a woman's health and protecting, just quote, potentiality of life.
Sure.
That was Roe versus Wade was a compromise of that. So states could not prohibit abortions pre-viability.
Okay. And when you say pre-viability, that means that the fetus could not live outside of the woman's body.
Yeah, that's correct. The general understanding of viability. And there's a lot of controversy over viability, but what the Supreme Court did in Roe versus Wade was say that's around 24 weeks, first trimester. They used this trimester framework to analyze it and say states couldn't regulate or ban abortions before that point.
Okay. So then what has happened, and what happened this week? When you say this case that the Supreme Court is going to hear, you said it challenges Roe v. Wade. What does that actually mean?
So I think it also helps to understand a little bit more about the right to abortion itself. So Roe versus Wade happened, which recognized this general right that a woman has a right to choose. This kind of stems from a right to privacy and making personal decisions and, your personal autonomy. There were cases that came after Roe, though, that kind of diluted the right in some ways, meaning it wasn't as strong as it was before these challenges. And so there are, depending on where you live, you may or may not be familiar with these laws, but there are, some states require you to wait 24 hours before you can get an abortion. Some states might require counseling. They've tried a bunch of different things to either like kind of like delay an abortion or just kind of like hoops a woman has to jump through before she can seek an abortion.
Okay.
Some of those laws have been held to be constitutional. And so what the cases that came after Roe really did, really this one Planned Parenthood versus Casey, they created this kind of new standard, which was the undue burden standard. And so the question in abortion litigation was, does this law put too much of an obstacle in the path of a woman seeking an abortion? And if it does, that means it's unconstitutional.
Okay.
So that has been those challenges have happened. There were a couple recent cases in the last couple of years that there are regulations that regulate abortion providers and clinics. And those cases were found, the laws in those cases were found to be unconstitutional because the restrictions, I mean, some of them were really strict, and it would have meant either one abortion provider in the entire state of Louisiana, for instance, if the law was allowed to go into effect. And so the court had said in those cases that this was an undue burden on a woman seeking an abortion and unconstitutional. So far the right has been protected, but now the court's composition is different. We have a 6-3 conservative majority. And so what's significant about this case is this is called Dobbs versus Jackson Women's Health Organization. And it deals with a Mississippi law that outright bans abortions after 15 weeks with limited exceptions, I think for like health emergencies and if there's a fetal abnormality.
Okay.
This is unconstitutional under Roe versus Wade.
Sure.
But they passed it anyway, of course, with the hopes of getting to the Supreme Court. And so I think one of the things to understand too about how this works is people ask me all the time, they're like, I don't understand. If this is unconstitutional, why do states keep passing laws that aren't constitutional? It's like, well, that is how constitutional litigation works, is they're trying to get in front of the Supreme Court to change constitutional precedent. In this case, it'd be changing Roe versus Wade.
I have a question for you.
Yeah.
On that Mississippi law, I think I read it was called the Gestational Age Act. When that law is challenged in the state before we get to the Supreme Court, is there a stay on it, or how does that work? Like, let's say there's a woman who's 15 weeks, 1 day pregnant. Can she then seek an abortion, even though this law has been passed, while there's still ongoing litigation? Do you know the answer to that?
So typically I don't know a lot about Mississippi's other abortion laws, but with this, the lower court said that this was unconstitutional. So it would not be in effect currently.
So once it went to the lower court said, well, why don't we say, explain how the law even got challenged. Was it a pregnant woman like Roe v. Wade, or how did it get there?
It's actually an abortion provider that's challenging it, which is a whole nother issue and area of constitutional law that we won't get into. The reason it gets to the heart of Roe versus Wade is because the only question now before the Supreme Court is whether all pre-viability bans on elective abortions violate the Constitution. Under Roe versus Wade, they do. And so,
and I think, I'm sorry, I just want to back up because I think it's super important to explain for people who don't understand kind of how the Supreme Court decides cases or what they're deciding when a case gets there. A case could have all kinds of issues, but there's something called a question presented, and it's one question really. Sometimes there's multiple, but in this case, the court only decided to take up the one question, and the one question is whether all pre-viability bans on elective abortions violate the Constitution. And that's like, that is, like you said, a direct challenge because we already have the law that says it is. So what does that mean?
It's the first case to really directly challenge Roe versus Wade, and now it's going to be in front of the Supreme Court. And I think a way to think about how the Supreme Court works is the Supreme Court doesn't have to take most cases. It's required to take very few cases out there. And so what the state of Mississippi did was basically give the Supreme Court an invitation to be like, hey, reconsider Roe versus Wade. We're going to lay out the red carpet for you to do so. And all you have to do is accept our invitation. And now the Supreme Court has accepted that invitation. And we're waiting to see what the Supreme Court is actually going to say about it. And so this is an elective action of the Supreme Court. They did not have to take this case. That is why both sides of the aisle, so people who are pro-choice, that's why they're terrified, and people who are pro-life are really hopeful, because this case could be the one that changes things.
Well, and I kind of want to jump on that, although we're not here to give you our personal opinions about abortion and what we think is right or wrong. We're here to tell you about the law, but I think it's important that we touch on both sides of the aisle and what those arguments look like. So I think, let's just say from the pro-choice side, if the court decides that no, pre-viability bans on abortion don't violate the Constitution, then perhaps you could have laws passed that say no abortions ever, no abortions at 5 weeks, 6 weeks. I know I think there's a Texas law right now that I think is a 6 week or something, the fetal heartbeat ban. But so I think that's the concern on that side, that this will now, because they're not saying a time, they're not setting a date, weeks, that they're just talking about pre-viability. So that can be as early as conception.
Yeah, it'll be interesting to see how the Supreme Court finesses this, because it could mean the end of Roe versus Wade entirely. And there's a lot more. This is a pretty restrictive law of banning abortions at 15 weeks, still allowing for a few exceptions in limited circumstances. There are laws circulating. Some of them may even be already circulating in the lower courts, but there are certainly laws being introduced and passed that are even more restrictive than this, that don't allow those exceptions or don't allow exceptions for rape or incest. And, it's significant in that sense. And the Supreme Court could limit the holding in this case. They could keep Roe. They could also just reaffirm Roe versus Wade. But I think when you look at it, the way the Supreme Court works, it only takes 4 justices to decide whether to accept the invitation to take a case or not. So that's significant because there's settled law here. And 4 justices, it's a 6-3, conservative court, only took 4. 4 of them said, yes, let's take this. Why else do you want to take a case with settled law unless you plan on changing it? I mean, that's just kind of the thinking, right?
Sure.
This case has also been kind of like a roller coaster already, because the petition, or invitation as I'll call it, was filed by the state over a year ago. And the Supreme Court did what they conference cases. That's when the justices get together. This is a private proceeding, and they decide, are we going to take this case or not? And this case was reconferenced and revisited. I think I read today over 12 times, which is rare behavior.
So they just tabled it essentially. They're like, we'll just talk about it again next time.
Yeah. And so it kept everyone on edge, because every time the Supreme Court's going to do something, everyone was like, oh my God, are they going to decide on this case? And I started thinking, I was like, maybe they're not going to take it. And then they did. It won't be till next term. So the Supreme Court starts their terms in October. And typically the Supreme Court's year goes October to June-ish. And then they get a recess, which I want a job that gives me a 2-4-month recess. I'd be so down. But yeah, so it is very significant that they have now taken this case. The composition of the Supreme Court is different. Donald Trump appointed 3 justices. He nominated 3 justices to the Supreme Court. The first of which was Neil Gorsuch, who's a conservative guy, but he replaced another conservative guy, Antonin Scalia, who was super, super pro-life, super conservative, a really well-known Supreme Court justice for those reasons, and because he was also a brilliant writer. But then the tide started to change with the addition of Brett Kavanaugh. And he replaced a justice named Anthony Kennedy. And Anthony Kennedy was known as a swing justice, which means sometimes he voted with the liberals, sometimes he voted with the conservatives. And Brett Kavanaugh was not one of those. He was very conservative. So the tide starts changing. And then you had the death of Ruth Bader Ginsburg and the addition of Amy Coney Barrett, who was also very conservative and in her personal views, very much pro-life. And that really has opened the door to, that's why I said, I'm like, if the Supreme Court hadn't agreed to take this case, states are creating a number of opportunities for the Supreme Court to revisit Roe versus Wade. But now it's here.
Let's talk about the makeup of the court. So you've already explained how, we have a conservative Supreme Court at the moment, but these are not lawmakers. These are not, their personal opinions shouldn't come into play when making decisions or writing decisions, right? They have precedent. They have, they have case law that they're supposed to follow. And do you think they're just going to throw precedent right out the window and just make new law?
They've done it before.
Sure.
And like I said, this is also how constitutional challenges work. It's just that in this context, pro-choice advocates don't like what's happening. They don't like the policy outcome that the conservative legal movement is going for. And one way to kind of illustrate constitutional litigation and challenging precedent is Brown versus Board of Education was the case in 1954 that finally said that the separate but equal principle was unconstitutional and it ended legal segregation. It didn't end segregation because we know shit continued for a long time after that, but the Supreme Court's action in Brown versus Board of Education overturned constitutional precedent, which was Plessy versus Ferguson, which had held that no, as long as it's separate but equal, it's totally constitutional, which was bullshit, right? But that's how constitutional litigation works. It got challenged. If you can't challenge constitutional precedent, you can never, I mean, that would just be crazy. It's just that in this context, it's such a political issue with such division that pro-choice is like, no, we don't like what's happening. And it's certainly just a strategy that the conservative legal movement has used, is get these laws in front of the Supreme Court so they can just re-examine it. And
Sure.
Yeah, there's precedent.
But it seems as if, and I know the argument, well, the pro-life argument, I'm not going to talk about whether I think it's right or wrong, but in terms of the law, and we're talking about the pre-viability, that's where that argument gets a little bit dicey or wishy-washy, because what was pre-viability back in 1973 may not be this case today. We know that because of modern medicine, babies can live at being born much earlier than they could have back in 1973. So that's an argument you hear on the other side, is this trimester, the 24 weeks, it's so arbitrary in some respect. So that's what's interesting about this case, because it is another hard line case. The law it's not like a undue burden. It's not this isn't a burden. This is an outright ban, the law.
Yes, and that's what's significant. That's why it's at the heart of Roe versus Wade. And and this is a political issue that comes down to people's personal beliefs. And I think it's painted as like you're either for or you're against, but I actually think there are some shades of gray. You have people on the pro-life spectrum that still believe in abortion in instances of rape or incest or medical emergencies or severe fetus abnormalities. You have people on the pro-choice side that are like, yeah, I don't like abortion. I wouldn't get one myself, but it's not for me to decide. So there are some shades of gray, even though overall the issue is
it's polarized.
Yeah. It's just a little bit polarizing. Yeah. And it is kind of crazy when you think about it in a kind of grander esoteric kind of context. Is should 9 unelected people, these Supreme Court justices, be deciding these like super social political issues? That's a philosophical question that we won't solve today. I'm sorry to inform you, but
no, I know. It's just seems, and maybe it's because and I could be 100% wrong, so you can totally correct me because you're the constitutional law queen, but maybe it's because you like that? I just crowned you.
You have no idea. I am like high, like it was like
this is better than when you were crowned prom queen.
So much better.
I found out this week that Natasha was prom queen, which is just funny because it's like the polar opposite of my experience. But
I thought you were gonna say it's the polar opposite of being someone who's a constitutional law queen.
No, they can go hand in hand. No, but okay, so what I was gonna say before we got sidetracked by my beautiful compliment to you is maybe it's just because
getting hot in here.
Maybe it's because we just haven't seen something like this in our lifetime, right? We haven't dealt with such a huge issue that could be complete, like whether or not you believe in a right to abortion, if it could just be gone by October, well, it wouldn't be October, but you know what I'm saying? It can be heard and decided, and now you could live in a state that says you can no longer have an abortion. I mean, I just think maybe because we haven't lived through, we didn't live through Brown versus Board of Education. We haven't seen these huge changes in the law. And obviously that was a good thing, but I'm just saying it just seems like it's going to be so, it's just everyone's eyes are going to be watching because it's a big deal.
I think we should touch on that for a moment, because I think there's a lot of confusion out about what the end of Roe would actually mean if it happens, and what it would mean. It wouldn't immediately make abortion illegal.
Sure.
Taking away the right to an abortion, or at least like severely diluting it would mean that states would then be free to make it illegal if they wanted.
Yes.
So you would see a mixture, I think. You would see a lot of states immediately be like, hallelujah, this is illegal. You would see other states then make more effort probably to protect it. Like there are states now, Minnesota, Michigan is one of them, that has abortion as a right under their state's constitution, for instance.
Oh, wow.
And so you might see a lot of states like California, Oregon, the more liberal states, you're going to see you would see abortion laws passed, either rights protected under the state's constitution or rights passed under other state laws. But one of the things that I think is interesting that a lot of pro-choice activists and legal scholars are concerned about, and this is like way down the line, but I want to mention it because it's part of the overall kind of like where we're headed maybe, is that there is maybe going to be a strategy that they make that abortion becomes illegal nationwide and states are banned from allowing it. And the way to get there is actually, it was an argument in Roe versus Wade. The state of Texas, it dealt with a Texas law, argued that the fetus was a person that had rights. And so aborting a fetus violates a fetus's right to life under the 14th Amendment. And that may be this is like way down. I mean, this is not going to happen anytime soon, in my opinion, but it is something that was the argument in Roe versus Wade from Texas. And it is something that a lot of pro-choice people are like, that could happen. So just because.
Now you're like, you're going to sound alarms for the people who are pro-choice. I mean, pro-choice. People are going to start freaking out. So you're putting the cart before the horse. We'll see what happens.
Oh, it's definitely putting the cart before the horse, but I think it's just it's in the grand scheme of things of like, this is how significant this case is.
And I don't think that people fully understand, and it's totally fine because why would you be following every abortion case and whether it gets to the Supreme Court and what's going to happen. But we know that over the past at least couple of years, especially with the Donald Trump getting elected, it seems like abortion has just been a real hot button issue, more so lately than before. Or maybe I'm just paying closer attention. I really don't know.
I mean, this next year is going to be crazy. The Supreme Court hasn't set oral argument yet, so we don't know when this case will be argued. And the significance of an oral argument is that is the only time in the kind of process of a Supreme Court, the life of a case that gets to the Supreme Court. We don't know what the justices are thinking. They decide to take a case, which you can read into as much as you want, but the oral argument is the time we get to hear the justices ask questions and we overanalyze it and speculate as to what it means and where we think they're headed. But we probably won't get a decision in this case. We're looking at June of next year. So my prediction is in a year, little over a year, we're going to have a decision on this.
Yeah, it's pretty crazy. So I guess the way that I'm thinking of it, by looking at the question presented, and the only question the court is there to answer, they don't really have a lot of leeway within that to dilute the right. It seems as if it perhaps might strip the right by the question presented.
I agree with you, but I think they can finesse that. Sure. And make a really narrow holding.
So you think that this case, because a lot of times when cases get to the Supreme Court, and it might be a big case that seemingly would affect everyone, they can finesse it in a way, they can write it in a way where it's just so fact specific, or it's only applicable to just a very narrow, group of people. But this seems like it would really be applicable to a large majority of people.
Yeah, I think so. Look, I think the fact that they took the case means that something is going to happen in terms of, but it might be like it would be really random though to pick, because if you go by viability, that's what I think some people are thinking is they're not going to go by viability anymore.
I think I would agree with that.
And also viability is really tough. There's no bright line rule, and it's not like there's one moment in a pregnancy. However you feel about the issue personally, I don't think anyone can disagree that the amount of time and energy and resources spent on this issue on both sides of the aisle is just insane.
Totally. And I think, we're almost out of time. So I think we should kind of probably wrap it up with that. But I do think, and I appreciate that you pointed that out, that Roe versus Wade didn't stand for the idea that a woman has an absolute right to an abortion. And so we'll see what happens. I think everyone's going to be on the edge of their seat, no matter which side of the aisle you fall on. So
I am literally on the edge of my seat right now.
don't
Like,
fall off.
my ass is almost hanging off. Like I am like perched, like constitutional.
You're very
status.
upright. So if anyone wants to follow, the case is called Dobbs versus Jackson Women's Health Organization. There's not going to be much happening until October at the earliest, but as soon as there's any update, we'll let you know. So thanks for tuning in. And next week, no idea what we'll bring, but we'll figure it out then. Thank you.